Well, thanks so much. Because I am Canadian, I'm going to start in typical Canadian fashion by offering two apologies. So the first sorry is that we're coming in and talking about Canadian constitutional history at a gathering that is, of course, much more closely attuned with American debates, but I think Canadian constitutional history kind of offers a useful frame of reference and opportunities for intellectual comparison and contrast. So the second apology is more directed to the paper itself. So this is kind of a paper that has been, that I wrote with a Canadian audience in mind and for the Canadian Law Review scene. And so some of the intellectual scaffolding that I would have put into the paper had I been writing it for an American law review audience isn't in there. And so what I'm going to do kind of in my 10 minutes of remarks, because the Canadian Constitution is quite different and will of course be foreign to at least the vast majority of you, is give you kind of a couple key few points that I think will allow you to better contextualize this paper. So, the argument here, I think, is quite a simple one. The argument that I make is during the time period under consideration between kind of the late 1920s and the end of the Second World War, 1945, so this period that I call the long 1930s, the major legal thinkers and reformers of the era in Canada reasoned through the Constitution in Originalist terms. They might have disagreed as to the outcomes, but there was certainly much agreement over method. Okay, so I guess the first overarching point that I'll make is that this paper might seem surprising, I think, to an American audience that is more used to originalism as being treated as kind of at the top of the intellectual heap, and this is certainly not the case in Canada, where most judges today, especially on the Supreme Court of Canada, hew much more closely to a kind of living constitutionalist intellectual outlook. And so my point really here, this is a descriptive paper, but some of the normative considerations and conclusions that I draw at the end really hammer home the point that originalism is part of the Canadian tradition as well, even if it is no longer too common in modern jurisprudence. So in terms of substantive aspects of the Canadian Constitution, so first point is that it is a mixed constitution, right? So by that we mean that it is a constitution that is composed primarily of enacted text, and then there's also a very important unwritten element to the Constitution. The enacted component, it gets complicated because it's not contained in one single document. It's instead contained in several documents. There are probably two key pillars within that enacted constitutional edifice. The first one is the act that I discuss so closely here in this paper, which is the British North America Act of 1867, since renamed the rather anodyne Constitution Act of 1867. And then the other act with which some of you are probably familiar is the Constitution Act of 1982. So in 1982, Canadian authorities patriated the Constitution, which means that they agreed to an amending formula for the Constitution. Previously, before 1982, Canadians had to go to the United Kingdom Parliament to obtain a constitutional amendment. After 1982, there is agreement on the amending formulae, and so that is why we speak of the patriation of the Constitution. The other key aspect to the Constitution Act of 1982 is kind of the Canadian analog to the American Bill of Rights, contained in the document that we call the Canadian Charter of Rights and Freedoms. In terms of the unwritten element, not too much to explain here. The main manifestation of unwritten constitutionalism is, of course, this idea of constitutional convention, practices which are viewed as legally binding, and contrasted with political conventions, which are viewed as mere good practices. The second key point is, so what is kind of, why is the BNA Act of 1867 important? For our purposes, because the act sets forth the constitutional division of powers. So Section 91 of the Act lists out essentially the competencies that the federal government, which sits in Ottawa, has legislative authority over. Section 92 does the same with respect to provincial powers. So some of the things in Section 92, for example, property and civil rights. There are other relevant provisions of the BNA Act, but those are kind of the main two that we'll be discussing today. The third point Obviously, the Supreme Court of Canada is the highest court of appeal. It's the apex court in Canada today. This was not the case in the time period under consideration. Instead, the highest court was the Judicial Committee of the Privy Council. And quite unfortunately, I don't have the time to give you a full history of the JCPC, but it is a rather curious body. Not technically a court, so it was comprised of jurists. It was headed by the Lord Chancellor, who occupied a cabinet post in the British cabinet, and the document kind of, so this, quasi-court sat and heard disputes. They would render kind of a unanimous judgment, and the judgment really wasn't a judgment. It was instead a report, and it was a report to the sovereign. So technically it was non-binding, but for our intents and purposes, this body functions like a court. And why it's so important to talk about the JCPC, the Judicial Committee of the Privy Council, is that much of the ire, the nationalist ire during this period in Canada, is directed at the Judicial Committee. The basic contention, and I actually disagree with it on many different levels, but it's kind of the narrative that's important to lay down, and it is the narrative that was very popular in the 1930s, was that the JCPC had taken the Constitution Act, the British North America Act of 1867, and essentially flipped it on its head. The view was that the fathers of Confederation had intended to create a strong federal government based in Ottawa, and had intended to kind of allocate to the provincial governments very limited power. And the view that was popular in Canada at the time was the JCPC, through kind of robust, living constitutionalist methods, had essentially subverted the Constitution. And so kind of this opposition to the JCPC's outcomes, which often preferred provincial power at the expense of federal power, eventually led Canada to abolish appeals to the Judicial Committee of the Privy Council. Civil appeals to the throne are abolished in 1949, although the JCPC, of course, continues to sit as a court of final appeal for many jurisdictions within the Commonwealth of Nations. The last point, I'm looking at a very particular time period here, right, which is the Great Depression, but one of the arguments that I kind of mentioned briefly, and there's some information in the footnotes, is that originalism has been a key method of constitutional interpretation in Canada, at least since Confederation in 1867. And so if you go to kind of the early records, if you go to how the Supreme Court of Canada dealt with disputes in the early decades, if you go to the writings of prominent constitutional figures in kind of in the late 19th century, you'll see a lot of what seems to the modern reader, or at least the well-versed modern reader, as constitutional originalism. But there is most certainly a drop-off in the post-war period, and today most judges, of course, don't apply originalism in most domains of constitutional kind of adjudication, and they are, I would contend, very much living constitutionalists. So that kind of wraps it up. In terms of the paper itself, I've already laid out the basic argument. Essentially what I do, this is kind of applied originalism, is I make the point that the key thinkers of the time reasoned according to the different kind of substrands of originalist thought. So intentionalism was really the main form of originalism that the key legal thinkers of the 1930s deployed, but they also reasoned in public meaning terms. They used original methods, arguments, and at least a small group were, in fact, living constitutionalists, but really the weight, the centerpiece of the decade really goes to the originalists. And with that, I'll turn it over to Justice Brown.
Professor Lim's paper is an excellent paper. It's also quite careful, which I confess was a source of frustration as I read it, trying to identify holes that I could poke at. More than once, I think I'd uncovered one only to read on and found that he had covered it off with appropriate caveats and cautions. So let me focus on one possible missing piece to the story he tells that may be a fruitful subject of further inquiry, to tell the full story of what was going on in the 1930s. And then I'll have a thing to say about Professor Lim's point in his paper that there remain disputes about just what the original intentions of the founders were. And then I'll have a few observations about significance of the subject matter being actually interpreted by the Privy Council and its Canadian critics, because I think it's important to bear in mind that this was not a dispute about the interpretation of a rights instrument, but of a nuts and bolts statute of the Westminster Parliament. The possible missing piece is the Statute of Westminster of 1931, and by way of background, as Professor Lim mentioned, Canada was constituted originally by the enactment of the British North America Act in 1867, a statute of that Westminster Parliament, and by 1926, Canada, along with other quasi-autonomous states of the British Empire, so Australia, New Zealand, Irish Free State, Newfoundland, South Africa, in the face of, had acquired gradually autonomy over domestic affairs, but deferred to the UK with respect to foreign policy and with respect to the amendment of their constituting statutes. And in the face of enormous sacrifice by those countries, disproportionate sacrifice by those countries in the aftermath of World War I, it was their desire to achieve sovereignty over foreign policy, which led to the Imperial Conference of 1926, which led to a declaration, the Balfour Declaration, that these states were equal in status with the United Kingdom, both in domestic and in external matters. And this was what was formalized by the Statute of Westminster in 1931, which granted Canada full autonomy, except in those areas where Canada chose not to take advantage of that autonomy. And Canada at that time chose not to exercise autonomy over the amendment of its own constituting statute. And the reason for this, and here comes the point for Professor Lim's paper and for Originalists generally, was controversy within Canada over the power of amendment. Who could amend? Just the federal parliament, the provinces too, just some provinces, Quebec, Ontario, all of them. And so for 50 years, from the Statute of Westminster until 1981, when it was all finally settled, full legal sovereignty for Canada was stalled by the successive failures of prime ministers and the provincial premiers to agree on an amending formula. And this comes to my point. It seems inconceivable to me that writing on the heels of that Imperial Conference of 1926 and of the Statute of Westminster of 1931, that these academic commentators, these critics of the Privy Council, would not have had in mind the possible solution of taking up the opportunity foregone after the Statute of 1931 of Canada amending its own constituting instrument instead of going cap in hand to Westminster in order to undo what they thought to be wrong-headed provincialist decisions undermining Canada's version of the New Deal. For if they were employing originalist argumentation, even if unself-consciously so, and I think they would have been doing it unself-consciously, I think they would have recognized the possibility of amendment as a possible solution. Now, this doesn't mean that it would have been a straightforward solution. The provinces, undoubtedly Quebec, would have asserted themselves undoubtedly by demanding a voice in amendment, particularly after the election in 1936 of the militant Quebec nationalist Maurice Duplessis. And it's possible that until the defeat of Canada's Prime Minister Bennett in 1935, himself the author of these New Deal statutes, that his deep Alberta connections might have discouraged a conversely strong federal assertion of amending authority, and his replacement by the notoriously cautious, steady-as-she-goes Prime Minister Mackenzie King would have been a discouraging prospect, I think, for achieving sovereignty over anything new. Still, given the centrality of the power of amendment to originalist thinking, and as I say, even on self-conscious thinking, it is, as I say, inconceivable to me that these commentators wouldn't have given the promise of the Statute of Westminster some serious thought. And so I think that might be a fruitful area of exploration to augment this paper. So that's the first point. The second point I draw from Professor Lim's observation that in the Canadian context, a public meeting originalist might turn to the pre-Confederation debates not to seek out the framers' intent, but to determine how parliamentarians at the time understood a given phrase, since presumably their understanding of a given phrase would match the public's understanding of that phrase. I agree with that statement. The difficulty, however, is until very recently, we did not have a reliable record of the debates leading up to the 1867 Constitutional Pact. And this was, in fact, a point made by former Supreme Court Justice Ian Binney in a marvelous debate between him and Justice Scalia at McGill in 2007 over originalism. And so he asked, where do we find that record? There were no Hansard transcripts in these colonial legislatures. And really, we didn't really have anything. So while it might have been easy to reconstruct the opinion of what Sir John A. Macdonald, the real driver of Confederation, may have said about the meaning of different provisions under the proposed British North America Act, as Professor Lim's paper shows, that does not demonstrate the intention of the framers collectively. And there were certainly framers who were not strong centralists. Oliver Mowat, who became Ontario's deeply provincialist and ambitious premier, might have thought differently. So that was the problem. No record. We don't have these historical debates about our Constitution in Canada like you do. For most constitutional scholars in Canada, the world started in 1982. So, Année Zéro. So fortunately, but only very recently, I mean in the last 5 or 6 years, that record has been painstakingly reconstructed by the Canadian Constitution Foundation's Primary Documents Project. Full disclosure, my son is employed by them. It turns out that newspaper reporters with skills in shorthand recorded and published in their newspapers, it appears verbatim, every session of the colonial legislatures recording those debates that were discussing a federal union in the mid-1860s, not only of the colonies that united to form Canada, but of the colonies that opted out for a time of the idea, Prince Edward Island, Newfoundland, and of the colonies that just weren't interested in it at all, but were years later, 4 or 5 years later, British Columbia. So we now have a record, but the academic critics of the 1930s did not, and that, I think, left them with one hand tied behind their back when it came to deploying originalist arguments. So that's the second point. I think it would have been futile to speak, or at least speak confidently about original intention or original public meaning without having the benefit of a record of those intentions or those public meanings, at least as understood by the legislators of the day. Final word. I think in reading Professor Lim's paper, it is important to bear in mind just what the Privy Council was interpreting in these cases he discusses. What was the subject of these critiques? The British North America Act, while our constituting instrument, and we have now ennobled it by calling it a Constitution Act, wasn't really a constitution in the sense of a Bill of Rights. That came in 1982. That was Année Zéro. The British North America Act was a statute passed like any other statute by majority vote in the Westminster Parliament, a statute that Lord Sankey in a speech in Edwards described only as granting a constitution to Canada. And even as statutes go, when you read it, it's a garden variety nuts and bolts document. Here's how we go shutting down the old colonial administrations. Here's how we go about shutting down the customs houses between New Brunswick and Nova Scotia. And here are the rules of the road for the executive, legislative, and the judicial branches. Who builds the schools? Who manages horses on Sable Island? Who gets to appoint judges? And of course, the division of powers, and that's what that's about, is the subject of all these disputes that Professor Lim accounts. No breathless declarations of liberty, equality, fraternity. And so the law lords in Westminster, I think, understood their task not as interpreting a constitution, but as garden variety statutory construction, creating doctrines to give effect to ordinary statutory text. The stakes did not seem very high to them, even though it seemed very high to their Canadian critics. And even now, when the Supreme Court, which is dominated, this is quite correct, by living tree, living constitutionalist thinking, when they interpret the 1867 document as opposed to the 1982 document, it is treated mainly as statutory construction, and originalist methods are employed. Are the Métis Indians within the meaning of Parliament's power over Indians and lands reserved for Indians? Well, what did people understand as Indians back in the 1860s? Well, they took script, they did this, they did that, and here are some of the communications. And one of the great living tree constitutionalists in Canadian history, actually in Western judicial history, Rosie Abella, wrote a judgment that applied original public meaning argumentation. So even now, where the Supreme Court is much more federalist, federalist in the sense of centralist, even upholding the manifestly unconstitutional federal carbon tax, it understands its job in that case not as interpretation, not as living tree interpretation, but as construction, right? Augmenting the doctrines created by courts to fill in the gaps, to resolve concrete disputes. I'm at 10 minutes. That's probably enough for me.
I really have no response because I agree with everything that was just said. I think what I will do is maybe, I like this point to add in more about the Statute of Westminster. And there is certainly debate about what kind of amending formula or formulae Canada should adopt during this period. I think I mentioned in the paper that the House of Commons sets up a special committee to look into the question starting in 1935, and it's extremely complicated, but I do think I need more in there. But let's just open it up to questions, because if I were to continue, I would just be agreeing.
Preston, I agree with Judge Brown. Justice Brown, Judge Brown? Russ, great. It's an excellent paper, and I also think there is a lot of larger meaning to the paper to an American audience that you could draw out or emphasize, because the background here is my wife is Canadian, and so I could be ready for the Canadian job market. I did a background on English and Canadian legal history, and so I think there's more context to connect this to American history. I want to be clear that the timing lines up with the switch in time and the fight over the New Deal and the American Supreme Court. But instead of it being an American Supreme Court, it's the English Privy Council that is blocking, right? So just to clarify the stakes here, one of our great constitutional fights is a parallel story to yours, except there is this problem that you both have indicated. And it also reminds me of the fight that happened in Israel about Israel's constitution, because it's also the basic laws in Israel were passed by bare majorities in the Knesset, new sets of rules. So there's this problem, there's a category question of what makes a constitution. And it's highlighted by the fight in Israel. And Russ, what you're identifying here, emphasizing, is the British North America Act is a statute. But the deeper problem is that it is a statute passed in England. And correct me if I'm wrong, but even though this is controversial, the British North America Act grants both that Parliament, that not the Canadians, only the English Parliament can amend the Constitution, and it designates that the Privy Council is the highest court. So here's what's significant about this paper, is that it's the connection between, it's a battle over sovereignty. The fight that's happening in the 1930s is telling a story about Canadian sovereignty to overcome some textual problems. And they overcome the textual problems through originalism. And this is one of the compelling stories about why originalism is important as what law is, right? How do the Canadians tell a national story? Originalism is not just law. Originalism is a story that we, the people, tell about ourselves to form a nation. Sovereignty, and I would lean on Benedict Anderson's idea of imagined communities. Originalism is how a community imagines itself. You're showing a story how Canadian jurists engaged in an imagined community of Canadian sovereignty, and also Robert covers nomos and narrative, right? Originalism is also a narrative. It may be strange to think as cover as an originalist, but one of the reasons why originalism is important as a method to Canadians is because they had to overcome the textual problems of English sovereignty over Canada by constructing a nomos of their peoplehood. And that's what I found particularly powerful about this story, is that originalism is what brought these Canadians together to tell their own story. So I'm just trying to suggest ways of telling a larger story about the significance of originalism to everybody.
Thanks so much. Like Judd, I was struck by the parallels to the United States constitutional experience. Maybe this is a parochial perspective that many of us are going to share, but the thing that struck me, and particularly in the story you're telling, is the extent to which originalism featured in that debate on the American side as well by the critics of the controlling Supreme Court majority at the time. Roosevelt, is justifying his court packing scheme in part by, his criticism of the court is focused on this is inconsistent with the original constitutional design, right? People like Hamilton and Marshall were right about the broad scope of national power, and the Supreme Court is kind of constricting that, right? There are similar critiques of substantive due process, right? Both from politicians and from scholars like Edward Corwin and Charles Warren. Across a whole host of doctrines, you have this originalist perspective being used as a critique of judge-made doctrine. And I'm just wondering to the extent you've kind of looked at any of those parallels, to the extent there was any ferment or cross-border influence happening across those lines. It would be really fascinating to kind of get a sense of if those were totally distinct conversations or if they're happening in conversation with one another.
I wore my usual Constitution tie, which starts with really big letters, "We the people." And I noticed, apropos your presentation, the British North American Act is made by Parliament, although it begins with, whereas the provinces of Canada, Nova Scotia, and New Brunswick have expressed their desire, and then we're going to do something. I was looking in your paper for some account in the 1930s when Canada is more democratic, more of a sense of autonomy, I'm gathering from what you've said. For some necessity of distinguishing between the authority of Parliament's intent as opposed to the authority of the Canadian requesters. And I just wanted to, I'm recommending, I'd be delighted if you would consider elaborating a little bit more on this distinction. You have it in Herbert Smith's scheme, and it's in the order of the resolutions of the Quebec Conference, then the debate in the Canadian Parliament, and only last the Imperial Parliament. Whereas many of your other thinkers seem to just say, what did the British Parliament have to say? And every bone in my American body says, who? What do we, let's put the Canada back in America. And what do we in Canada have to say? What did we say when we requested it? What did we say when we received it? And I'm guessing that Herbert Smith put those in that order for a reason. It's not just temporal, it might even be authoritative to place even if the Canadians don't make it, the Canadian request is the most important original meaning.
Okay, great. So these are all great comments. I'll take them in reverse order. So, David, it's an excellent point. The question, the answer is a rather easier one. So there are good methodological reasons to kind of de-emphasize the records of the Westminster Parliament when we are kind of going back to 1867, and that's for the simple reason that the kind of enactment process at Westminster was extremely brief. So there's really not, if you look into the record, there's not too much to go off of. And instead, the reason why kind of these great thinkers of the 1930s are really tilling the Canadian field, so to speak, are because that's where really all of the relevant debates were held. So at the Quebec Conference and at the London Conference. And, I think the colonial office's approach at this point in London was to just kind of let the Canadians figure it out for themselves and then to rubber stamp at the end what they had requested. So it wasn't a very muscular effort on the part of Westminster to really amend what the Canadians had done. It was a light touch. Second point, so Ryan's point kind of about cross-border influences at this point in time. It's a very interesting question, and I haven't looked into it nearly enough, so I'm going to give you a slightly paradoxical answer. So the first part of the answer is that despite growing American influence at this time, definitely the spiritual home for English Canadians is very much still the United Kingdom, right? So many Canadians still see themselves as essentially British at this time. And so that's a very important piece of it. Now, this is not to say that there is no American influence on kind of the Canadian legal market at the time. Indeed, there was. The way in which that manifested, and it's an interesting question that you've posed, because I certainly know of no convincing evidence that the Canadian thinkers of the time were really well steeped in originalist debates in the United States, but what they were well steeped in was the progressive and realist attacks of the time. So if you look into the debates of the 1930s, everyone had read Roscoe Pound. They were all very familiar with Roscoe Pound, and Vincent MacDonald, who's one of the chaps that I profile in the paper, really is just kind of a Canadian version of Roscoe Pound in many ways. Now, they were very much, the Canadian thinkers at the time were also very much taken with the realists, although fewer of them went quite so far as the realists. So all to say that I think it's actually a very interesting question that you've posed, and it's a question that I think connects very well with what Jed is asking. And there are a lot of interesting themes here. I guess the one point that I will affirm that I'll certainly draw out from what Jed is offering is it's very important to see originalism in the Canadian context at this time as an expression of nationalism, right? But it's a very carefully articulated nationalism, right? Because it's not a bunch of Canadian legal thinkers coming out and saying that we need to cut ties with the British Empire. Oh no, not at all, right? And so even kind of the most robust of the Canadian legal thinkers still frame their arguments very carefully. They say, we are very much we maintain this idea of empire. We are we believe that the British Commonwealth of Nations, as it's emerging, is the ultimate means of securing liberty for the highest number of people on Earth at the time. But at the same time, there is this kind of quiet, brooding, red-blooded nationalism which sees Canada as being part of the British Empire, but as seeing Canadian judges and lawyers as having kind of more of a say in domestic constitutional disputes. A couple points about what the BNA Act says and what it doesn't say. So the BNA Act articulates a lot of what Professor Balkin would term hardwired rules, and this is what Justice Brown has just talked about. If you read through the BNA Act of 1867, and very few people have, a lot of it is actually quite boring to the modern reader. But there are certain aspects that it didn't kind of set in stone, and it's just relevant to your question, Jed. So the BNA Act of 1867 actually doesn't say that the JCPC needed, right, to be the final court of appeal in Canada. That was kind of a part that was left to the evolution of custom. The portion of the BNA Act which David read out, the preamble, the last part of it, which he didn't read out, says that the confederating provinces are setting down a constitution that is in principle similar to that of the United Kingdom, right? So custom is very important, and indeed when the Privy Council, and this is a big moment that I didn't get to talk about, but it's actually the Privy Council that comes out and rules that Canada has the right to abolish appeals to the Privy Council, right? A very unique example of basically, maybe from American eyes, a colonial institution or a colonial power saying, no, we actually don't have the power to continue on in the same way. That's very much due to the presence, the strength, and the tempo of custom in the Canadian context. I think I'll leave it at there for now, unless. Okay.
Great. So I think this is a great paper, but is going to be a much better book project that when you can zoom out and see a lot of the moving parts together, it's going to work a lot better. I don't know how that fits with the plan for tenure, but I would definitely encourage you to think about that long term, because in my view, the story as it's currently told, it leaves me wanting in a couple of respects. So in part, I think the story is actually, it kind of needs to be a story about the emergence of living constitutionalism as a counterpoint. And I kind of wonder about the way in which the narrative is structured now, and then also kind of what the lessons are from that narrative. So just to give you a sense of kind of a basic point about the narrative, you say that the kind of form of the debate was an intra-originalist conflict, and then you say the conclusion is the originalists won. And that's just weird. Like, I'm not, from a narrative standpoint, I'm not sure what I'm supposed to be getting out of that. And it would be cooler if there were, and maybe there just isn't, this will get to my next point, but if there were a narrative about the originalists, intra-originalist debate. And right now, as the paper is structured, if there is a narrative, I totally lost it. Because what I see is just all sorts of people making all sorts of different types of historical arguments. And I don't have any sense in which those arguments are, and maybe it's just because I don't know who any of these people are, and so I can't sort of follow the narrative. But it just seems like lots of people making lots of arguments. And if there were a way in which there's a coherence to that debate, and you could tell it through narrative form and then talk about who wins and loses within the intra-originalist fight, that would be great.
Right.
I'm a little bit skeptical of that because maybe, to Russ's point, really what's going on is just conventional legal analysis. They haven't absorbed a kind of living constitutionalist perspective. And so really all that's happening here is just a bunch of people for political reasons are making arguments that draw on history in various ways that suit their positions. And it's not really at core a theoretical debate. It's just the theory is kind of at the surface and is really being driven by some sort of broader constellation of political views, which is fine, right? Like that's how ideas emerge, is not because people are initially committed to the ideas themselves, but because there's a kind of political undercurrent to them. And then the thing that kind of I'm a little bit curious about, feel free to not respond to this, but I am really curious, is when it is that living constitutionalism emerges. And I don't think it's fair. I mean, others might push back on this, which is fine, but I don't think it's quite fair to say like Pound and the early stage legal realists are living constitutionalists. I think that they have a view about the perils of formalism, but they don't have the view that like the judge is supposed to be the active agent of shaping the law and promotion of a kind of forward-looking aim, at least in the way that you see later on. Mm-hmm. And so I wonder about that. Like, can you have a debate about originalism or living constitutionalism in a world in which there isn't judicial lawmaking as like a thing, where we're still kind of operating under this older concept? Thanks.
Really enjoyed the paper. It's really a fascinating paper, and I learned a lot from it. So 2 little suggestions and then a bigger point. So tiny suggestion number 1 is, I was very curious about the role of the so-called living tree doctrine during this period. This may be obvious to Canadian readers, but it's not obvious, I think, to your non-Canadian readers. So if I understand the history right, the living tree first comes in 1929 in the Persons case. And so that's right before this period you're discussing. So it's possible, I just don't know what the story is. I think you should tell the story. Did the living tree disappear during this period and then rebound later? What happened? Second suggestion is about the wider implications of the paper. This is very much an American-centric comment, but in the United States, one position that is frequently asserted about originalism is that it is uniquely American, that it was invented out of whole cloth in the late 60s, early 70s, and that, as Chris Sprigman sometimes puts it, and that no one in any country, anywhere else in the world, has ever thought originalism is a sensible approach. And of course, this suggests that that whole story might be off. So those are the 2 little suggestions. The bigger comment is sort of about the way you're using the theoretical framing. And and in particular, the way that you're using framework originalism. So there's a lot of commonality between framework originalism and the form of public meaning originalism that focuses on ordinary meaning, right? You have a set of statements that identify Canadian legal arguments during this period with framework originalism. All of the quotes that you use just happen to use some version of the root word to frame, right? But that doesn't make it framework originalism. And in particular, the two things I think of as the defining characteristics of framework originalism that would contrast it with other forms of ordinary meaning, public meaning originalism, would be, number one, a thin theory of communicative content that focuses on semantics and that excludes consideration of pragmatic enrichment, to the extent necessary to make sense of the text, I think in Jack's words. And number two, the use of a multiple modalities approach. How many modalities, Jack? 18? A lot. 11 modalities in the construction zone. So I didn't see any of that in your characterization of framework originalism. So, and maybe you are using the phrase framework and originalism in a sense different from the way Jack uses it, or maybe there's stuff going on not reported in the paper that would make the Canadian practice closer to sort of framework originalism as fully articulated by Jack.
Right.
Thank you both for the terrific presentations, and thank you for this paper. It's great to bring more Canadian constitutional law to an American audience. I think it's really enriching for us. My very small comment is that Judge Bradley Miller has written about how really in Canada, although judges claim they're doing living tree originalism, there's much more originalism right now than these judges say. Like, they might be flagging the banner of living tree constitutionalism, but then they do originalism. And he argues that there's a pretty common thread that you can trace even from the very first living tree case. And so he and I have had conversations about this, but I think he also wrote up some of that argument in a piece at the Common Good Constitutionalism Symposium at Harvard last October. So maybe just go track that down. I saw you cited him a couple times, but you're not engaging with this particular argument yet. So if you think he's wrong and that they're really not doing originalism right now, it'd be interesting to know why. Or maybe you think that, there's an element of what he's saying that's correct. The judges just don't know that they're doing originalism, or like they're getting closer towards originalism even while they're calling it living tree constitutionalism. I'd be interested to know what you think about that.
Absolutely. So, all great comments. I'll start with Judd. So I agree that a book project would be more appropriate, because I think it would kind of clear up some of the narratives that I put here. So maybe it a shelf for a little bit, but a great suggestion. There is a different way of telling this story, and I think how the story has often been told is actually about the rise of realism and debates over statutory interpretation. Okay, so one of the classic narratives here that a great kind of Canadian intellectual historian, Richard Risk, has advanced was really the issue was that in the late 19th century, and the Privy Council very much hewed to this, it was the dominance of formalism, right? So specifically how that manifested in the reading of the B&A Act was very textualist methods and very, very sharp limits on recourse to outside sources. And outside sources would include the Confederation debates. And so and certainly, I don't think this is incorrect. In some ways, I see it as quite consistent with originalist thinking, but there's this idea that the thinkers of the 1930s advanced that this is wrong and that you need to, in order to make sense of the BNA Act, really open up a lot of these old historical documents and place kind of individual constitutional disputes into their fuller context. I know that's not exactly kind of an answer to your question, but I think part of the struggle here is that there is this other narrative that I think applies but doesn't completely intersect with the story that I'm telling. As to the question about living constitutionalism, so this ties in beautifully with Stephanie's comment. So I agree, unsurprisingly, with Justice Miller's fantastic set of different articles. So kind of the article that I think I'll maybe summarize here, there's a very famous case, okay, in Canadian constitutional history known as the Persons case, which dealt with the ability of women to be appointed to the Senate, okay, and it was a huge flashpoint in the debate over how to interpret the Constitution, and in that case, in delivering the report of the Judicial Committee of the Privy Council, Lord Sankey, one of the Privy Councillors, wrote that the BNA Act of 1867 planted in Canada a living tree capable of growth, but basically he takes the tree metaphor all the way and says that the roots of the tree are extremely important. And the reason I bring this up, and it is a very important debate in Canadian constitutional history, is the traditional view, okay, the traditional view of this case is that it is completely synonymous with living unconstrained, living constitutionalism, because, of course, as we know, as Larry Solomon has written, living constitutionalism itself includes a whole range of views, right? But many have read that case as completely consonant with robust living constitutionalism. Justice Miller disagrees. He reads the case as being completely consistent with public meaning originalism, and I agree with that. Now, regardless of whether or not you agree with Justice Miller or kind of the more conventional account, it certainly should be said that many lawyers at the time, okay, when the Persons case was published, viewed Lord Sankey's language as promising a much more liberal method of interpretation. So regardless of who's right, certainly many during this time period that I'm looking at did view it as kind of part and parcel of a new living constitutionalism. And so this is actually, there's a companion piece to this one that I've written that I'm finalizing up, which really looks at the constitutional thought of one of the thinkers from this period, Vincent MacDonald, and I argue that he did the most, really, in the 20th century to think up a very robust version of living constitutionalism, and his view was not at all unconstrained, and this is where I'm getting back to your point, Judd, about Roscoe Pound, but it was essentially a common law constitutionalism, right? So the view was, and I'll just use MacDonald's words, but the view was, of course, judges have discretion. Of course, judges can advance the Constitution. They can read in their own interpretations into law. They can adapt. They can thereby adapt the Constitution to meet the needs of the times. Bigger amendments should be left to the legislature. In that case, it was the Westminster Parliament. And that I see as quite consonant with parts of what Roscoe Pound was writing about. So maybe Roscoe Pound is not consonant with the full-throated living constitutionalism of today, but certainly Vincent MacDonald saw great kind of consonance between his own views and those of Roscoe Pound. So not a complete answer, but essentially to agree with the question. Larry, look, I agree with your major comment, and I think I have evidence that I kind of didn't throw in there, and I think I should throw that in there. And the other thing that I'll say is part of the struggle here, and I think you see me struggle through it in the paper, is that there is at least a substratum of living constitutionalism going on during this time period. And of course, many thinkers pay lip service to the Fathers of Confederation, but I think it's kind of, it's a fairly faint-hearted argument that I've advanced that framework originalism really was a major component of the legal thinking of the decade, but I agree with your suggestion and I'll take it. not much to say about the wider implications of the paper. I think you raise a good point. The living tree doctrine, I think I've covered it well. So I actually have nothing to add other than what I've said.
I mean, the living tree metaphor, I think, is great for originalists. We were talking earlier. I mean, a tree stays in one place, right? So the Edwards Persons case, 1929, well, you got a tree. It's in one place, and it changes a little bit. That's an awful lot like Euclid versus Ambler Realty from 1926, where you've got fixed meaning and changing a degree of elasticity in the application, but not the meaning of terms. And I think working that in would be great. We were talking earlier. Miller stuff is fantastic. Second thought. I mean, I guess I should apologize for just kind of typical American self-absorption. But it's a variant on Ryan's question about the 30s. But I'm very curious what these Canadians are saying in 1867 about the nature of federalism, just because there's this massive dispute on the same continent about the nature of federalism in 1867. Jim Allen, who is a Canadian who we were visiting here at the same time, and he was going on and on about how in 1900 in Australia, there's this fascinating debate about stuff like Lochner, and do they want to put a Bill of Rights in the Australian Constitution? They say, no, we don't. We want to have mostly just structural stuff because of their reflections on what was going on in America. To what extent did the 1867 Canadians think about putting some kind of equal citizenship idea, or I don't know, disqualifying insurrectionists? Probably not. But which is what to what extent does 1867 stuff going on north of the border, north of that border, tell us about just the nature of federalism, in North America, all of North America?
Thanks very much. I really enjoyed the paper. I apologize because I know very little about the Canadian experience and can only speak to our own. But I wanted to make 2 points. The first, sort of echoing Ryan and building on it, is that it is actually kind of remarkable how originalist FDR was, at least in theory. In the fireside chat where he's proposing court packing, he talks about how the framers used broad and general language capable of meeting evolution and change, how the evil conservative court is trying, quote, to read into the Constitution language the framers refused to write into the Constitution. I mean, his whole attack on the Supreme Court is it's not being originalist enough. Mm-hmm. And I find that interesting in part because that isn't the only avenue they could have taken. I mean, that is not the avenue that Professor Woodrow Wilson, some 40 years before would have taken. He would have said, no, the Constitution's just bad. Lochner is a sort of decent reading of it. I mean, Lochner itself didn't exist at that point, but the old court's approach to it was correct as a matter of reading the Constitution. This is just a bad Constitution. We should get rid of it and do something else. And so I wonder, is this essentially the same phenomenon in both places? And is this part of something I think Jack might have mentioned in an earlier book, which is that originalism is often a way of changing whatever you're doing right now and saying that whatever we're doing, so it's the current practices have fallen away from the true practice. And so that's what we should be doing. The second point that I wanted to ask about is, how did it change? So I think it's an interesting question how, in the American experience, originalism, after having been invoked against the pre-New Deal court, then became sort of tied to the pre-New Deal court, and it's sort of the bad old days, whereas now, finally, we have reached the broad sunlit uplands. I think it's interesting to look at Casey from '92, talks about how, we discovered, and so it talks about how, the lesson that seemed unmistakable to most people by 1937, which was that rules against minimum wages had caused the Depression, basically, that they were unable to, inconsistent with satisfying minimal levels of human welfare. And so there's this idea that the lesson of history is that originalism is bad and is linked to the Depression and sort of old things. And how did it come to be in Canada that a movement which could be invoked for Canadian identity and for the ability of the central government to do things it needed to do, then by today now is seen as a sort of retrograde approach. And this may be outside the period of your paper, but I think it's a question that would be worth asking.
Let me put a slightly different question, in a sense, to the two of you, which is this. The 1982 Patrioted Constitution was adopted by the Federal Parliament of Canada without the consent of Quebec, as I understand it, that Quebec, the separatist government in Quebec wouldn't endorse the bill to patriate the Constitution. And it's almost a little as though under Article 7 of the American Constitution, one of the states, Rhode Island or one of the others, hadn't ratified and nonetheless was, unlike Article 7, deemed part of the new constitutional government. And the question is, to what extent that fact bears or should bear on the legitimacy of originalism in construing the 1982 Constitution. To what extent, if at all, is the non-consent of one of the provincial governments, does it undermine the potential authority of the original intent of the 1982 Constitution makers?
Chris, you make some great points. There's not much to quibble with regarding your first point about the living tree. I essentially agree with that characterization. So I'll give a little bit more context about this foundational moment of 1867 because I think it might prove helpful. Obviously, the Constitution Act, or the British North America Act of 1867 is passed in the aftermath of the American Civil War, right? And so I'll begin with the key caveat that Justice Brown kind of mentioned, which is that for much of this period, there really isn't the thickest original record available, and so it was inevitable that a lot of judges in the early period referred to a really small coterie of sources, so particularly the writings and the speeches of Sir John A. Macdonald, who had been, of course, one of the chief architects of Confederation, but of course not the only architect of Confederation. And so certainly the fact that 1867 comes on the heels of the Civil War led many of the great thinkers of the 1930s, and of course many jurists in the early period in Canadian history, to conclude that, of course, the fathers of Confederation had intended a strong federal government. For how could they have wanted a constitution that gave more power to the states? Hadn't excessive state power been the cause of the American Civil War? And so that historical moment is very important. There is an interesting historical argument that I think has kind of been debunked, so I'm not relying on it, I'm just mentioning it. But Judah Benjamin, who was a Confederate secretary, argued a lot of the big Canadian cases before the Judicial Committee of the Privy Council when he was in London. So make of that what you will, but certainly he had the Privy Council's ear. I don't think even the mainstream Canadian historians would disagree with me in saying that. Now, the point as to rights, it's an interesting question, and it's one that I've thought about kind of in the time period of the 1930s to 1950s, and I believe the answer that most Canadians at the time would have given you was that, look, we don't need an enacted Bill of Rights because we rely on British custom, on the British traditions, and Parliament has always been protective of minority rights. Specifically how the argument is made, and I know Vincent MacDonald makes it very powerfully, is that, look, with the principle of responsible government, which is that the government is responsible to Parliament, so Parliament can boot government out of government and form a government with the Governor General's consent. Essentially, any kind of rights abuses can be immediately remedied. That's one point. The second point was that by kind of political convention at this, certainly by the early 20th century, the federal government, the cabinet specifically, was thought by many to be quite representative in terms of demographics. So it usually had representation from Quebec, it had representation from across the country, and so I think the view, certainly the view up until kind of the post-war period is that, look, we can just leave it to Parliament. Parliament's going to be fine. Parliament will protect our rights. And that kind of changes in the post-war period for some reasons that great historians have pointed out in the Canadian tradition. But to kind of give you the one-phrase answer, there's increasing trampling upon rights in the post-war era. It starts during the Second World War with the internment of Japanese Canadians. In the aftermath of the Second World War, you have kind of mass targeting of those with kind of communist sympathies, and then you have kind of crackdowns on the Jehovah's Witnesses in Quebec. So there's a growing rights consciousness, but it doesn't come until after the Second World War. Stephen Sachs, okay, great point about FDR. Look, I think that's actually, it would be a very interesting paper to look at reasoning during this period in Canada and compare it with reasoning in the constitutional context in the United States. I think it would be a great paper. And, you know, one different element in the Canadian puzzle is, of course, the foreign element, right? So in the United States, it's a purely domestic argument. It's an American court, it's an American opposition. Here, things are very much complicated by the fact that it's a foreign court in the eyes of at least some, right? It's a board sitting in London at a time when many Canadians were clamoring for more independence, and that is, it's a significant part of the puzzle that differentiates, but all to say that I think that would be a very interesting avenue of inquiry. How did things change in the post-war period? I should provide another caveat here that this is a question that I am actually looking into now, and so I only have kind of tentative responses to that. So I'll give it in two forms. The first is a changed economic outlook. Okay, and so with the Second World War, you have the apogee, the rise, the embrace of Keynesian economics. Okay, and so a lot of the problems that you had during the Great Depression more or less evaporate with the new wartime economy and the embrace of deficit financing. And so a lot of the immediate economic crisis that had really proved the spur of all of this, kind of, it at least receded into the background as the government, the federal order of government, became more sophisticated in its handling of the economy, number one, and number two, became much more sophisticated in giving grants of money to the provinces. Okay, and so that second point is key in that the Canadian Supreme Court begins to embrace in the post-war period this idea of cooperative federalism, this idea that the federal order of government and the provincial order of government, they can cooperate and they can do a lot of things that they can't do on their own, and that contrasted with a more rigid reading of the division of powers that the Privy Council had advanced. But again, a very tentative answer because there's so much to mine there that I'm just simply not familiar with. And I think I'm going to leave the last question to Justice Brown to answer first.
Oh. If I can just, actually, I'm just going to elaborate on is this on?
I think so.
Yeah, okay. Yeah. I'm going to elaborate on the comment about the Civil War. I have now started to read the record of pre-Confederation debates because my son has been doing data entry for the Canadian Constitution Foundation. The Civil War figured prominently in the thinking of colonial legislators, not just in Canada, but in New Brunswick and Nova Scotia, about wanting to confederate. But it wasn't so much about a strong central authority versus a weak, versus a strong provincial authority. It was concerned that the United States was going to turn on British North America because of the British subtle and sometimes not so subtle in the case of the CSS Alabama support for the Confederacy in the Civil War. And there was a lot of concern expressed by legislators about that, just sort of an interesting factoid. Right. So does the absence of Quebec's consent to the constitutional arrangement delegitimize originalism? I think the answer is no, because it hasn't delegitimized the Constitution, the application of the Constitution to Quebec. So a bit of background, Pierre Trudeau, Prime Minister of Canada at the time, initially sought to patriate the Constitution unilaterally without any provincial support. And that was derailed by a couple of things. First, it was derailed by a report by the Foreign Affairs Committee of the House of Commons in Westminster, authored by the Secretary of the Committee, John Finnis, later teacher of Justice Gorsuch and of Justice Miller. And he said, no, there should be significant provincial support and also support of what we now call the First Nations. Then the Supreme Court of Canada decided what's called the Patriation Reference, divided decision, bitterly divided decision, but a majority that you cobble from the different decisions said there needed to be significant provincial support. It did not define significant. Eventually, it looked like it was going to be just 7 provinces supporting it. Quebec, in fairness to Trudeau, he was in an impossible situation. Quebec would not have supported any constitutional arrangement. It was a separatist government at the time. It just wasn't going to do that. And Ontario, which is obviously a very significant province in the Confederation, and New Brunswick were opposed. What we now know, and we've only discovered in the last few years, since a sort of a post-mortem representation by the Premier of Ontario at the time, is that he told Trudeau that he was going to be on his own. At least he wasn't going to have Ontario if he didn't agree to the clause that the other provinces were demanding, which was a notwithstanding clause, allowing them to override certain sections of the Charter of Rights in cases of when legislating. The irony is they've hardly used it. But in any event, Trudeau had to stoop to conquer. He did. He ended up having 9 provinces support, not Quebec. But the Constitution still applies to Quebec. Brian Mulroney made a valiant attempt in the late 1980s, early 1990s to bring Quebec in. It didn't work. Not Quebec's fault this time. But that's how it is. But the Constitution applies in Quebec. Nobody really denies its applicability to Quebec. The Quebec Attorney General brings constitutional challenges all the time, as it did to the Indigenous Child Welfare federal scheme, which was pronounced upon and Quebec lost last Friday. So if the Constitution has legitimacy in Quebec, then I think if originalism doesn't have legitimacy in Quebec, it has nothing to do with the failure to endorse the Constitution. That's my one-off.
I suppose I'm a troika unto myself. So I'll offer three quick thoughts. The first is, I agree with Steve that one thing that one could take from this paper is support for the general idea that originalism is a technology of legal change, right? That's what it was for FDR. That's what it is for some of your actors. That's for much of, and the reason is because it's the thing that comes to sweep away whatever the accumulated error is, right? It's the Protestant Reformation against the Catholic Church. Second, I often don't know. I learned a ton from your paper and also from your comments and Russ's comments here, and loved learning it. I was not always clear what the difference was between originalism and people making historical claims about a constitution. I think it would help if it was more clear whether you were using originalism, the term, to mean a particular kind of subset of that other thing, and if so, what it was. I think that does a lot of work here, right? And the third thing is just a reservation about Judd's intervention, most of which I agreed with, which is as a caution, and maybe the terminology doesn't work this way in Canada, but in the United States, certainly as an original matter, the family of approaches that go by the name living constitutionalism don't need to be committed to an idea of judicial lawmaking, judicially generated change, forward-looking judicial updating. Many living constitutional theories and approaches do have that as a component. But the first applications of the idea of living constitutionalism in the United States early in the 20th century are not about that, right? They're about the ability of other decision makers in the government, legislatures and administrators and so forth, to change the operating arrangements from the ones that are understood previously to perhaps have been required by a constraining constitution. And there's like Holmes, right, and his pacifism is a form of living constitutionalism in this sense. Frankfurters also, right? That is to say that the idea is that the arrangements change, rather than a particular commitment to the judges being the ones who change it. And I think it's I think it's a distinction worth keeping in mind. I also feel like a few times you talked about, in the same vein, full-throated, unconstrained living constitutionalism. I'm not aware of any living constitutionalism that understands itself to be unconstrained, right? That is, if it's constitutionalism, it's constrained, right, in some way. It may not be constrained by the same things that people operating other theories think it should be constrained by, right? And maybe you meant that to be implicit, right? But if it's constitutionalism, it's constrained by something.
Those are great points. I don't really have much of a response. I think, one thing here is kind of to agree with the second point, but certainly I think a lot of the arguments that were being deployed at the time were kind of what we would maybe in the modern day refer to as historical traditionalism. So kind of, historical practice, and in some ways maybe sometimes compatible with originalism and sometimes not, but either way hard to separate out. But I appreciate the point. I need to think more about point 3. It makes sense to me, and I agree completely with kind of this idea of originalism as a typology of legal change, but it's not always, I would suppose, a typology of legal change. It is certainly here. Thanks.
Let's thank Preston and Russell for the paper.